The Supreme Court recently turned down review on several rifle and magazine ban challenges. However, there's one case they previously sent back to the lower courts with instructions to watch carefully. That case just became extremely important. The Trump Department of Justice has now officially stated that they believe magazine and rifle bans violate the Second Amendment. With oral arguments scheduled in just a couple of weeks, let's break down what's happening in this critical case. I'm going to discuss two important cases that challenge a state's ban on certain rifles and magazines. These are consolidated challenges that have reached the Third Circuit en banc panel. The magazine portion of this case was recently granted, vacated, and remanded back to the lower court for a new decision based on the Supreme Court's 6-3 ruling in New York State Rifle and Pistol Association v. Bruin. The District Court recently issued a ruling in two consolidated cases, ANJRPC v. Platkin and Cheeseman v. Platkin. The court's decision contains one of the most confusing Second Amendment analyses I've seen in quite some time. Here's what makes this ruling so perplexing. The court found that a state's ban on Colt AR-15s is unconstitutional and must be struck down. However, the court then refused to rule on other aspects of the rifle bans in place in the state. At the same time, they acknowledged that magazines holding more than 10 rounds are arms protected by the Second Amendment, but decided states could still restrict or outright ban them. This problematic ruling is now heading for en banc panel review in the Third Circuit on October 15th. The Trump Department of Justice has thrown its support behind the challenge, arguing that state rifle bans and magazine bans like the ones in New Jersey need to be struck down. We got a surprise development recently when the Third Circuit en banc panel decided on their own to take review of this case from the three-judge panel that had already heard oral arguments. Essentially, the en banc panel said, "Although you've heard oral arguments on this case, we're going to take this ourselves and issue our own ruling." This move prompted the Trump DOJ to jump into the challenge. The Trump DOJ recently filed an amicus brief arguing that magazine and rifle bans violate the Second Amendment. This was a significant move by the administration, and it's encouraging to see as the case moves forward to oral arguments on October 15th. There's also a strong possibility that the Trump DOJ might participate in those oral arguments. For those unfamiliar with this case, it involves New Jersey's ban on so-called assault weapons and their magazine restrictions. Regarding the magazine bans in the state, back in 2018, New Jersey passed Assembly Bill 2761, banning the possession of firearm magazines that hold more than 10 rounds. This case initially went to the Supreme Court in 2022, but was remanded back to the District Court after the Supreme Court issued their Bruin ruling. The District Court then consolidated multiple cases, deciding to rule on both the state's magazine ban and rifle ban at the same time. In that ruling, the District Court showed it wasn't going to faithfully apply Bruin because the judge believed the Supreme Court got the analysis wrong in Bruin and simply didn't agree with it. The judge stated that it's hard to accept the Supreme Court's pronouncements that certain firearms policy choices are off the table when frequently radicalized, individuals possess and use the same firearms for evil purposes. Despite this disagreement, the court said it still had to follow Bruin in some ways. The result was a hodgepodge ruling where the court claimed to follow Bruin, but came to this mixed decision. Only AR-15 bans are unconstitutional, but the court didn't address any other rifle bans. The court also said magazines are protected arms, but states could still restrict them because of technological developments and a nuanced approach, claiming it's in the public's best interest to restrict access to those magazines. This troubling ruling is now being appealed to the Third Circuit Court of Appeals. The case was originally argued on July 1st before a three-judge panel in the Third Circuit, and they were set to rule on the case. However, everything has changed. Before the three-judge panel could issue their ruling, the en banc panel in the Third Circuit decided on their own to issue a notice that they're going to grant review to this case. They're going to sua sponte take review of this case and issue their own determination. It seems like the state of New Jersey senses trouble ahead. New Jersey recently submitted a supplemental brief to the en banc panel arguing that they should follow what the Second Circuit recently ruled in a different case dealing with rifles and magazines. The supplemental notice from the state of New Jersey references NAGR versus Lamont, which rejected Second Amendment challenges to restrictions on rifles and magazines. So New Jersey is scrambling to support their state bans in light of the en banc panel taking this case on their own. Things got even worse for them because now Harlan Dillon, on behalf of the Trump administration, filed an amicus brief in support of striking down these bans. In the brief filed by the Trump DOJ, they argue that the Second Amendment guarantees the right of the people to keep and bear arms. The United States understands it to be undisputed in this case that AR-15s qualify as arms, and for good reason. The Supreme Court has recognized that at the founding, all firearms constituted arms. The brief addresses two principles of Second Amendment doctrine that have confused other courts. First, the Second Amendment does not secure the right to possess and carry arms only for self-defense or sporting-related purposes, but rather for all traditionally lawful purposes. History and tradition confirm that these purposes include the common defense. Second, the Second Amendment protects arms that are in common use among law-abiding citizens for lawful purposes. To be sure, some courts have criticized this common use test, but the Supreme Court cases clearly show it is the governing test for courts determining which arms the Second Amendment protects. Not only that, but the common use test has deep roots in both English and American law. The Second Amendment's irreducible minimum guarantee incorporates both principles. Legislators may not completely ban arms that are in common use among law-abiding citizens for lawful purposes without running afoul of the Constitution. Applying these principles to the state law at issue here, New Jersey's complete bans on possessing rifles such as AR-15s and magazines with the capacity to hold more than 10 rounds violates the Second Amendment. They conclude that the court must make clear that the Second Amendment does not allow New Jersey to ban the most popular rifle in America, the AR-15. Nor does it allow New Jersey to ban magazines holding more than 10 rounds, which are significantly more popular than AR-15s themselves. The Trump DOJ argues that an outright ban on rifles and magazines is unconstitutional. This will be argued before the en banc panel in the Third Circuit in just a couple of weeks on October 15th. Very soon, the Third Circuit en banc panel is going to hear arguments in this case. We're going to watch closely to see how this plays out during those arguments. The Third Circuit has issued some pro-Second Amendment decisions lately, so this could be another case that comes out positively. But we'll have to see how the arguments develop and what the en banc panel's demeanor is like. What questions do they ask? Which hypotheticals do they explore? It's also interesting to consider whether the Trump DOJ will push to actually join those oral arguments within the next week or so. We've seen recently that Harmeet Dillon and the Trump administration have taken an active role in many Second Amendment cases. Recently, she actually joined the oral arguments in the Illinois PICA challenge in the Seventh Circuit, which also dealt with rifle bans and magazine bans in Illinois. This would be another significant oral argument before the Third Circuit en banc panel, and it's actually a bit more significant in its relevance than the Illinois case because, again, this is at a higher level. This is at the en banc panel level in the Third Circuit, and really just one step away from Supreme Court review. We're going to wait and see if the Trump DOJ tries to get involved in those oral arguments happening in just a couple of weeks, and then we'll see what happens during those oral arguments on October 15th. Again, we're going to watch this closely to see how it develops. As we get more information, I'll let you know. If you enjoyed this video and want to support the channel, one of the best ways to do that is to subscribe to the channel. There's a lot waiting for you there. As always, thank you so much for all of your support.